So to talk to us about the hows, the whys, and the wherefores, let's head to Abuja. Marpa.
Thank you, Chamberlain. We have with us this morning two gentlemen to do justice to this topic. We have Mazi Afamo Osigwe, who's a senior advocate of Nigeria. You're welcome to Sunrise Daily this morning.
Thanks, Makwe.
He's also a former General Secretary of the Nigerian Bar Association. And we also have with us Mr. Utum Eteng, who is a former member, Presidential Committee on Constitution and Electoral Review. That committee was headed by Senator Ken Namani. You're welcome to Sunrise Daily this morning.
Thank you. Good morning, Nigerians. Thank you.
Well, gentlemen, you have heard the former president, and there is enough examples on the ground to buttress what it is that he's trying to point that he's trying to make. Some people will say they agree completely with the president, especially when we look at where we're copying our democracy from. The major example is the United States, and we saw what happened in the wake of the at the end of the elections when former President Donald Trump tried to take the matter to the courts. As much as possible, it was seen that they deferred back to the will of the people as expressed in the ballot boxes. Do you think that what the president is saying here is truly feasible here in Nigeria? What are your thoughts? Let me start with you, Mazi.
Well, I think from my understanding, the former president simply expressing a dissatisfaction with the involvement of the judiciary in the electoral process. But that would appear to be blaming the wrong person. And I thought he should have started with blaming the politicians who create the environment for the judiciary to get involved in the first place. And making reference to the United States example and trying to expect what obtains there to happen here is trying to compare apple with oranges. There they have a political culture and system and an electoral process that brings out an outcome that the people have confidence in. And that's not as much as one can say about our own electoral process. And then suggesting that the judiciary should not be able to determine outcome is to suggest that the ability of the judiciary to adjudicate in disputes referred to it and then determine one way or the other what should happen should be taken away from the judiciary. Because if you take it away from them in electoral processes or matters, you may as well suggest that in all that contestation between individuals, that the court should not also take a decision. It should also refer the parties to start all over again. And I don't think that there will be an end. Because when you do a fresh election again, there's likelihood that there will be disputes again. So if you go to court and the court finds that there is reason, so you refer it to fresh election and you continue on and ad infinitum. And I think we should be much more concerned about our electoral process that produces outcomes that do not engender trust in the people, that allows things to so affect it that people go away shaking their head to say, look, the declared result does not reflect the will of the people. The UN Declaration of Human Rights says that election, the purpose of election is to enable people express their will as to their government, more like a referendum on a government, or between the individuals who have presented themselves. And when you suggest that either people should accept the outcome, whichever way it comes about, or that the judiciary should be incapable of putting an end to these disputes, is to me will create more confusion or lead to more uncertainty. If the parties, the government in power, the individuals, all major stakeholders, the electoral umpire, they will all do their work such that when the result is out, the loser will congratulate the winner. Then such a suggestion will be nice. But when we have a winner takes it all mentality where people want to win at all costs, those in power do not want those in opposition to rear their head, to be able to campaign freely. They ban your campaign work, they destroy your billboards. Then security agencies are in some cases deployed to pin down people, to make it difficult for people to live there. You make all manner of policy decisions. Then for so long people challenge the outcome of election. Let me stop talks first so that you ask your next question to mine.
As you're speaking, you know, my mind is going back to my days in secondary school, where, you know, you're given a math sum, or something in mathematics, and the teacher is more interested in the workings rather than the results. Some people will say that what the ex-president has said is more about that the judiciary should be more involved in the workings rather than the outcomes, and he thinks that, you know, perhaps we should strengthen our electoral process more so that the outcomes will be more acceptable to the people. Can you really fault that? Let me come to you, sir.
Thank you, Margaret. I think I want to start by saying, to a very large extent, I adopt the reasoning of my learned friend as advanced here this morning. And I want to say that I respect the person of former President Goodluck Jonathan. What he expressed was his personal opinion.
Indeed.
He is entitled to that and protected by the Constitution. Be that as it may, I want to pass that expression, that opinion so expressed, as a bit unfortunate and to some extent misplaced, because what he suggested by implication means the declaration of candidates as winners should not be the constitutional prerogative of the courts. Indeed. It should be that of the electoral body itself. In a civilized clime like us, constitutionally, it is an aberration for one to be a judge in his own cause. INEC to conduct an election and to declare the winner, and that's the end. No, it is like taking us back to the Professor Iwu days.
No, so he hasn't said, and I'm not holding brief for the president, but I think if one were to be able to play an extended version of what he said that the courts should be able to, say the process, determine if the process was fair or not. If the process wasn't fair, he thinks the powers of the courts should stop at declaring a rerun rather than declaring a winner of the elections.
Yes. Before you declare or call for a rerun,
yes,
there must be a declaration of one being right and the other being correct. And who, as at today in Nigeria, has the prerogative to do that? For now, it is INEC. And it is wrong, in my very humble opinion, to put the cart before the horse.
Let me also ask you this, because you're a member of a political party, if I'm correct.
Yes.
Your party, and I think almost every party, does the APC, right? Or have you defected? You
know me more than I know myself. Oh, yes, go on.
Now, I'd like you to, is that correct?
Yes,
that is still correct,
I am.
Right? Indeed. So, I mean, your party has held the short end of the stick in cases where the court has declared elections in favor of another party. Your party has also benefited from courts being able to declare. I'll give you two quick examples. There was the situation in Bayelsa, where it wasn't even an electoral, well, maybe some people say it's an electoral matter. It was a matter of certificates. And that's how your party...
It's a pre-election matter.
Yes, where your party lost, the seat, the governorship seat. And then in Imo, yes, you held the long end of the stick, as it were. In both of these cases, do you think that the decision of the courts should have simply stopped with the process? What is your thinking?
I do not know what you mean by the process. I want to say the process must produce a result. And it is the result of the process that is to be challenged or that is to be addressed. Now, I want certain impressions to be corrected. We have, despite our exposures, continually made mistakes. And the mistakes are such that we have not been able to separate the ought position, ought, O-U-G-H-T, position, from the is position. If we are able to separate that, you will agree with me that certain decisions of court are based on the is position. That is why, to a very large extent, the court, in giving its own opinions from the evidence before me, that is the is position. The odd position is almost always taken by even the non-lawyers or people who are not involved. It ought to have been this. At that point, the judiciary is accused by those who are non-lawyers. I am not saying that the judiciary is perfect. No, they are human beings. They cannot be perfect as such. But when we are able to draw this thin line, ought to in most cases is the moral aspect of it. It should have been this, but the court said it is this. So, for instance, the case of Imo, or the cases of Imo and that of Bayelsa, I think, as a very senior lawyer, I must confess to you that by my training and background, I lack the locus to question, especially in a place like this, the decision of the apex court of the country. Because we are told, and I believe it at my level, I'm a lawyer of 36 years in practice. One of the definitions of law is, the law is what the judges say is a law. So we take it from that point of view. There must be reasons, whether right reasons or wrong reasons, because somebody must be hurt somewhere along the line. He may peddle a kind of explanation that will sound plausible in the eyes of some and otherwise. So I see completely the decision of the Supreme Court being right, since as at now, that's the last bus stop.
Well, that's your training as a lawyer. For the majority of people who go to the polls, they're not lawyers. And sometimes, you know, they will question whether or not their decision, their will as a people who went to the polls, stood under the sun, and went through the entire process, hasn't been usurped by the decisions of the court. Not because they didn't cast their ballot properly, but because perhaps somewhere along the line the process was flawed. Do you think that there could be room for remediation in the National Assembly, looking at how the laws have been, you know, enacted?
Well, our electoral laws have been amended, and the Constitution has been amended several times to improve on the electoral process. And it would appear that the more we have these amendments, the more litigations we have. But I think the topic for discussion today is the scope of the involvement of the judiciary in the electoral process. And we took a cue from the statement by former President Jonathan, where he suggested that the court should not be able to make a declaration. Now let me start by saying that the courts decide cases based on facts presented before them and what has been proven, and then they apply the law to them. So in appropriate cases, the courts actually do not make a declaration, they order a rerun, depending on what has been proved or what is in contention between the parties. If I give, for example, a case presented to the court is that from the votes cast, if they had collected the results properly, I ought to have been declared winner, not the other individual. And indeed, the court finds that from the totality of the votes cast, which were improperly collated, that Mr. B, who went to court, ought to be declared the winner, not Mr. A. Should the court order a rerun in that circumstance? So it is the facts that will determine what the court does.
Period.
If, for example...
So do you think, for instance, the courts, the order of the court could be different? I mean, I don't know.
No, and if I'm a judge,
yes,
and a man comes to me to say, from the votes cast in my own constituency, from the results sheets made available to all agents, signed by everybody, I scored the majority of votes and met all the constitutional requirements to be declared winner. But the wrong person was declared winner. And the court finds as proved that this is the case. don't you think it would be unfair for the court to order that a fresh election be held in light of the evidence which suggests that the man who has approached the court, the petitioner, ought to be declared the winner? So the facts must be applied to the decision of the court will be based on what is proven. I understand the worries of people that there seems to be over-judicialization of our electoral process. But the point has to be made that the politicians and the electoral process heap this blame on the doorsteps of the judiciary. If things are done properly, if the candidates do not employ the use of thugs to unleash violence, to snatch ballot boxes, to burn results, to prevent collation of results, the court will not be involved.
So,
sorry, let me just say this. And you talked about the people not feeling, even in the United States, the supporters of Trump, many of them still believe that that Trump won. So it's not always that how the people feel may actually be a reflection of what is, which is why I understand what he means by the difference between ought and is. So there are some people that say we ought to have been declared winner, but we were not. But the reality may be that you were rightly not declared the winner. It depends on the facts and circumstances of the case. I'm sorry, I wanted to ask a question there.
Yeah, I was saying that perhaps the order of the court could be different. If, for instance, a candidate comes to court and says, you know, given the collation papers that we were given, or the election results, or the result sheets that we have, if you add this and add this and add this, we should be declared winner rightfully. And the court finds that to be so. Do you think, for instance, they could say, INEC, you know, use this particular result sheet and, you know, ensure that whoever should rightfully be declared winner is declared winner? Do you think that...
There's something we say in law that there must be an end to litigation. You give room for people to mount further challenge. Then you ask yourself, of what use is a court which cannot make any positive decision? By telling INEC, do your work. No. And then a fresh round of litigation may ensue about, oh, you can't do it, go about doing it. And somebody may even try to start all over, assuming it was the Supreme Court that said this, or the Court of Appeal, if it's the last court in that instance. Somebody may go back to a trial court and say, no, INEC was wrong, we were not invited, this was not done. It may never end. As much as I share the skepticism of people about the role the courts have played, because in some cases people feel that the court's decision did not reflect the will of the people, which is natural, which may not, so because of that, people do not want the court to be much involved. But to suggest that in all cases, the court should hands off, wash its hands like Pilate, and I say, INEC, you do your work, do fresh election, compute and declare a winner. You know, that would be a recipe for inconclusiveness, institutional inconclusiveness, because we may never end. The court, as an adjudicator, must take a decision. People may not always like his decision, but the court must make that decision, as painful as it may be to those who lose in some circumstance. But we should work on strengthening our electoral process, our political culture, so that people will have confidence in it, so that people will accept the outcome of elections if they are properly conducted, so that the involvement of the courts will thereby be greatly reduced. And I'm sure the judiciary is not happy about the role they play. People have to be posted to different places to sit in tribunals away from their homes. The courts have to deliver judgments within 60 days at the Court of Appeal or filing of an appeal at the Supreme Court, and they're overworked. And it disrupts their normal judicial work because since the constitution has placed a time frame, it means most other work has to be suspended so that they can attend to electoral matters. And it means commercial cases are not being treated, criminal matters are not being treated. And we want foreign direct investment, and we're emphasizing or giving priority to electoral matters. The court would also want to be seen that they do not delay in the disposal of these other cases, so that people will have confidence that our judiciary is such that can give justice in all matters other than electoral matters.
Well, let's quickly flip this to Lagos now, where my colleagues have questions for you.
Well, let me begin with you, Mazi Osigwe. When you say that we need to strengthen the process, exactly what do you mean? Because what you have said has been said for as far back as I can remember. After every election, we've talked about having a conversation about around our electoral laws, around our electoral processes and all. The challenge people are having is, on the one hand, the people have spoken through the ballot paper, And on the other hand, the cases in court seemingly, just as you said a little while ago, upturn the position or the choice of the people, and then make the declaration, and it would seem like the choice of the people is relegated compared to the choice of the courts. But first, when you say we should strengthen the process, exactly what do you mean, and how do you think we should go about it?
Now, I talked about a political system and the electoral system. They all play a role. The political environment has a bearing on the outcome of an electoral process. Now, you talk about involvement of security agencies, the unwillingness of security agencies to apprehend people, or in cases, reported cases of security agents aiding electoral violence, electoral malpractices. Now, we talk about governments in power, be it at the states or federal or local government level, not allowing the opposition to thrive or taking steps to frustrate other persons from participating in the process. Now, we talk about the integrity of the electoral process, ensuring that the votes count, ensuring that the ballot papers are not hijacked, or that from EC8, I think that's what it's called, yes. The allegation that sometimes some parties have advanced copy of it and fill it in, and that what is submitted before the election, or that what is submitted is different. If you read some reported cases, you see both opponents submitting certified true copies of from EC8, purported from INEC, with different figures. We need to do so many things that will strengthen the system such that it will be transparent, so that the voting process will be such that when results are declared, people will go away knowing that that system has been tamper-proof, or such that whatever is the outcome of it is such that people cannot but accept the outcome. There are a whole lot of institutional things that can be done, which we may not have adequate time to discuss here, but which I believe Chief Utum, who has been part of the Electoral Reform Committee, has dealt extensively, may be better placed to talk about. But we have to strengthen the system so that issues of snatching of ballot boxes, I've seen an election being conducted in some countries, and you don't see sign of any uniform security person in sight, and yet nobody makes any attempt to snatch anything, or to doctor results, or to tamper with the process. I don't know, but I think we can get to that point. But do we have the will to do it? Underage voting, intimidation of opponents, arrest and detention of persons, use of thugs, so many things. We all know it. So what can we do to make for a credible electoral process?
Yeah, but Mr. Sigwe,
talk about when I say strengthening the process.
We'll get the point about, we'll understand what you're saying about the process, but there are still cases or times that, you know, when you say justice must not be done, but to be seen to have been done. Because I think part of what some may glean from what the former president is saying, that even when those cases are in court, because that opinion, which many now think, oh no, justice goes to the highest bidder when it comes to electoral cases. Because there are times wherein you see the mood. The people feel this is who we want. And then for perhaps based on technicalities or certain other such matters, cases are struck out. So in that scenario, can't it be said that perhaps those courts or the judges or whatever it is can wean themselves of that external influence and then, as much as possible, align with what the will of the people predominantly is? Can't that happen?
Chamberlain, I don't know whether you're suggesting that the court should go to the general public to have an opinion poll done to know what the people before giving a judgment. I don't know what that's you're suggesting. But if that's not what you're suggesting, let me take Bayelsa case for example. The law is that any candidate who has made a false declaration or presented a forged document to INEC shall be disqualified from standing as a candidate in that election. And there was an allegation that the deputy governor in that election presented such documents, and the Federal High Court rendered a judgment before the election disqualifying him. It means that the APC, which ultimately won that election, had no validly nominated candidate, gubernatorial and deputy gubernatorial candidate. Now, the law simply is, it means that APC is not in the race, so all the votes that were cast for APC were more or less null and void. So should the court, because the will of the people as expressed in that election was a preference for the APC. Now, since this is a preference for APC, despite this legal disability, we should not declare any person winner and allow the Bayelsans to yet again have a bite at the election so that they will produce an APC candidate as winner.
Well, not
the law.
Okay, you know what? We'll come back to some of these matters and perhaps get Chief Otun to equally respond. That will be in just a moment. Please join us again. All right, welcome back. Let me ask you this, Mr. Sigwe. There was this, I think it was in March, where the retired Justice of the Supreme Court, Olabode Rhodes Vival, said many previous decisions of the Apex Court should be laid to rest and never followed. So he noted that there have been several occasions where that they were bound. I mean, this was just talking about some of those decisions that have been taken by the Supreme Court, how he didn't think it made any sense. That was a big headline at that time. So doesn't this lend credence to what many have been saying about those judges? Because I remember some politicians equally accused judiciary of giving black market injunctions. And some of them even say, how do you give ex parte? You don't follow certain processes. So all of those things are all associated with the electoral process.
Chamberlain, I think the retired Honorable Justice Bode Rhodes Vival is being quoted out of context. I recall he was talking about precedents. He emphasized the importance of following precedents, but said that where precedents are found not to meet the modern needs of the society, that the court should be able to depart from it. And I do not recall he was talking about the electoral process. Indeed, in his valedictory speech where he took that from, he said that with respect to conduct of election, that the burden should be placed on INEC to prove that the election was conducted in substantial compliance with the law. That's what he said. Now, when we talk about black market injunction, well, that is a term that unfortunately has crept into our whatever in the last few years, I think people use that to mean injunction that or orders of court that appear suspicious. Now, where it is proven that any person involved in the electoral process has been involved in bribe taking or corrupt practice, in some certain cases, is a criminal offense, and NJC has in appropriate cases taken actions against the judicial officers involved. But that is not to say that everybody who is involved in these electoral cases takes bribe. Such a suggestion should not be encouraged. It is also possible that because of the nature of politics, the way we play our politics, people sometimes also encourage these unfounded beliefs in order to discredit a process which has not favored them. It's only in Nigeria you see a man who has not scored up to 10% of the votes, challenging the entire process and asking to be declared winner, even when it is obvious that by no stretch of imagination could he or she have imagined the winner. We should not bring down the house because some of the outcomes do not favor us. Well, I still insist that there is need for us to have some reforms, both political and electoral and institutional, to strengthen our electoral process. I do not think that it now calls for, or it justifies a call for the judiciary to be incapable of making a pronouncement one way or the other with respect to electoral disputes that have been presented to them. It does not justify the court simply saying INEC do a fresh election, even in circumstances where it would be unfair for a fresh election to be ordered. The law does not respect any person, and sometimes the law, when applied to certain situations, may not be pleasing to the general public or the persons who may not have benefited from it. But that does not suggest that a corrupt act has been involved. Where you present a candidate who is not qualified, who has presented forged document, and that candidate is disqualified by the court, you live with the consequences of your action, because the parties are supposed to understand the onerous duty placed on them to ensure that those they put forward for an election have not presented forged candidates or are qualified to stand for that election in the first place. They're supposed to do some form of due diligence.
You know,
and where they fail to do so, and the court decisions against them and probably robs them of a victory they would ordinarily have enjoyed, they only have themselves to blame.
Right, Mr. Sigwe, you know, this is...
the judiciary as a whole...
Pardon me, this is fundamentally about the will of the people, right? And I mean, when you say that punishing everybody as a result of just one person's sin, in quote, I'm not sure if that is fair enough. But let me take this back to Mr. Tumeteng and just build up again. This is fundamentally about the will of the people. The former president said that, well, I'm not sure he said that the court should be entirely removed from that process. He was just asking for a limit to what the court can do. I mean, thus far, no more, especially because it has to do with the will of the people. I mean, the people didn't just go out there to vote on that day for jamboree's sakes. They went to elect a leader, which is a fundamental of democracy. It's a government of the people, by the people, and for the people. It didn't quite mention the judiciary or a select few in the judiciary. So in the light of the will of the people, if we could just go back to build that again, do you align with the former president saying, well, the court should be limited in that area?
Well, I'm sure the question is directed
no, it's me. For you, actually.
I want to say that, you see, the will of the people is an elastic expression. Elastic in the sense that in the conduct of an election, several processes are taken into consideration. Even after one has been declared a winner, there are other areas the law has provided that has to be looked into by the other party to see if there was substantial compliance with that. You may score 100% of the votes, but there may not be substantial compliance with the rule of law as provided by the Electoral Act. In that kind of a situation, the people's mandate cannot take precedent over the rule of the court, over conditions placed by the court before one is finally declared. You see, the problem we have in this country is the attitude of Nigerians. It's our own attitude. For instance, before the Electoral Act 2010 and the subsequent amendments, it was a provision of the Electoral Act that wherever elections are to be conducted and a candidate files a document which is presumed not to be completely correct by the other side, that issue is raised before the electoral body, INEC. And INEC was given the legal authority, clearance, to look at it and disqualify the candidate. At least as Nigerians, because of our attitude, we can recall what then happened. How many persons were said to have been disqualified unjustly and they still went back to the same court to ask for the interpretation or explanation or protection of the court? The court will have to do that. If we talk about the process, for instance, I give you an example of a situation I personally took part in. When President Muhammad Buhari came on board as the president of this country, on the 4th of October 2016, he put forward a 24-man electoral constitution and electoral review or reform panel or committee, headed by no other person than the former president of the Senate, Ken Namani. And indeed, the question or the task before the committee was to look at the constitution and look at the electoral act and see how best elections can be conducted in the country. And this particular issue raised by the former president was raised in almost all the 6 geopolitical zones visited. And the answer, unanimous answer to a very large extent, was that, please, remove this responsibility from INEC, let the courts being the hope of the common man, decide whoever is properly elected. It will be a terrible invitation to chaos if we allow it at large.
Well, Mr. Eteng, if I could just come in here.
Yes.
I just want to be sure, in trying to solve a problem, don't you think we're creating one? But first, let me try to get more insight on that. So you're saying that if people go to vote, for example, INEC conducts an election, people troop out en masse and they vote for a candidate, and it's clear who the winner is at the end of the day. Are you saying that INEC should then take that result to the court for the court to look through it and say, well, it followed due process, so you can announce the winner, or the court should announce the winner?
Forbid,
but what exactly?
God forbid, I should not be understood saying that. What I have in mind, and which of course is applicable, is one scores 100% of the votes. That's correct. 100% of the votes. That makes him ahead of his opponent. I am saying that that is not the end of the matter. That cannot be the end of the matter. If, for instance, take the Bayelsa case as an example. If at the end of the day, with the 100% votes cast being the will of the people is subject to the rule of law. And it is shown, like it was shown in Bayelsa, that, oh, the man we have given 100% of our votes did not get even elementary 6 or school certificate as required by the Constitution. And it is so proven. There is no court of law that will shut its eyes and say the people have spoken. The people must speak in accordance with the provisions of the law.
Pardon me, is it the will of the people? Is it the will of the people that should be subject to the rule of law, or the conduct and the process that should be subject to the rule of law? Because the will of the people is the will of the people. I want this person to be my leader. I shouldn't have to subject that to a constitution, for example. So isn't it the process that brings about that leader, the build-up, that should be subject to the rule of law?
The process has to be complete. It has to be complete in the sense that if you come out to want to vie for a position, the law presupposes that you will be qualified, you will be a Nigerian citizen or whatever. And if out of ignorance or oversight, deliberate sometimes, one suppresses information about his qualification. That's a process. And the process is that if at the end of the day, you are able to establish that information has been suppressed as to the age of the winner who has gotten the votes, which is the will of the people, and that is challenged, the court is bound to look at that and be satisfied that he got or he did not get the qualifying factors right before he was elected.
Well, Mr. Eteng, let me
I am making.
Okay, now let me come at you with this one, or perhaps rephrase or take a look at the same question Kade asked from another light. There are 4 critical elements in the process we are talking about here. The last of them being the courts. The first is the political party, then the people, then INEC. No, beg you. The political party, then INEC, then the people, then the courts. At the beginning of it all is the political party that fields candidates. So when you say the process concluding itself, perhaps you should look at the beginning of the process. Because it is the political party that, for want of a better word, erroneously fields a candidate that is not qualified in the first place. Consequently, the conclusion of the process cannot be clean, because just as you have cited, if the political party fielded a candidate that was not qualified in the first place, we have already set up the judiciary, as Mr. Osigwe said the other time, to intervene in the matter. So shouldn't we be looking at the process from the perspective or from the responsibility of the political parties themselves, who literally set up, if we can use the term, the judiciary for the end of the process?
Well, that is correct, but what you have to understand is if a political party knowingly and willingly conceal information about a candidate it's fielding for an election, if at the end of the day that candidate wins and these facts come to the public line and there is a challenge, if the court declares the candidate fielded by the party who has won, scored the highest number of votes, as declares him as one who is not properly elected because he did not fulfill all the requirements required by law, the political party suffers. You are a Nigerian, we are all Nigerians. We know people suppress a lot of information. People suppress information even against their wives. And when this comes to the public domain, one is helpless. I have a personal experience that I didn't even know, without mentioning name, that the friend have been calling lawyer was not even a lawyer. He was arguing cases in court like a lawyer. Arguing cases and winning some cases in court. But the process of becoming a lawyer was exposed to be faulty. He was exposed to be faulty. That he was not qualified to be admitted in the university. And you see, he has won cases. He has practiced law for some time. And I've joined those who didn't know to call him my senior. But he failed when the truth came to light. It is a process of becoming a lawyer that was challenged and that robbed him of that. It's the same thing in the election.
Exactly. So then, Mr. Ten, can we say specifically that it is the political parties that invite the judiciary into the process because of the faulty process that they initiate in the first place?
The party cannot invite the judiciary knowingly into the process when they are aware that the candidate fielded by them, by the party, lacks what it takes to be a candidate. It is not the party, strictly speaking. But one could say it is the candidate who has been declared the loser by the court who actually brought about the problem that eventually threw him out. Because you know yourself. You see, we know ourselves. No matter how we pretend, we know ourselves. We know our shortcomings. But sometimes, due to certain circumstances and influence, we could suppress certain things. And when those things are suppressed, at the end of the day, they come out to be known by others. You see how we try to hide and take the shame. And take the shame. It's not the political party. The party must work upon the information given to him because such information is given on oath. And when equally, information given on oath is discovered not to be correct.
Well, Mr. Tang, let me ask...
the candidate must...
Yeah, we'll get your point to that. Let me bring Mr. Osigwe on this one because, I mean, we were speaking earlier about comments attributed to retired Honorable Justice Rhodes Vival. Well, in the same breath, he equally did say that most elections are often resolved by courts simply because most politicians are never satisfied with the results announced by the regulatory body charged with the conduct of elections, which is INEC. And then he spoke about a case which delivered in 2016. That was an election dispute involving, it was a governorship election dispute. And he said, a careful reading and understanding of deciding authorities would show that a petitioner had an uphill task proving his petition in accordance with the Electoral Act. He therefore recommended the Electoral Act should be amended to shift the burden of proof to INEC to prove that he conducted a fair and reasonable elections. Isn't this part of what the former president is talking about in terms of the limitations of how the courts can go about electoral matters so that it really be seen that they are not unnecessarily, as it were, interfering?
No, Chamberlain, I I still beg to differ. That's not what he meant. He was trying, the Honorable Justice Roosevelt in that statement was trying to say that the petitioner has an uphill task. If you read a number of the decisions, if you present your, for example, your state collation officer or local government collation officer or senatorial, they said, questions you put to him, were you in the polling unit? In other words, suggesting that whatever he may have said was hearsay. Sometimes you tender documents and they say you cannot speak to these documents because you are not the author. So there are differences. So what he was trying to say is that even in cases where it looks as if the complaints have basis, the person who is complaining has a difficulty in proving them. Permit me to digress a bit to address an issue, question raised by Kayode and your other colleague when you are talking about the will of the people and involvement of the court. Let me make this point. Candidates are sponsored by political parties. And in situations where they may have been fraud or forgery by a candidate, the party is as much a victim of that fraud as the public that may have reposed confidence in that individual by giving him the majority votes. Because parties screen their candidates. And this individual must have used this candidate, because if the party had discovered at the screening stage that these documents were forged, the party would not have shielded him. So the party is also the victim as much as those who voted for them. And the public or the people who express their will by voting for an individual who may have used violence or who may have forged documents to secure victory in an election will stand or fall with him. And if there be any legal impediment attached to him, it destroys the will of the people expressed in the votes that gave him victory. Sure. It's not sentiments. So if the man ought not to run, he's not legally qualified and he doctored his age. For example, let's talk about Salisu Buhari in 1999, who had to doctor his age to qualify to run for House of Reps and ultimately a Vice Speaker. Will it be right to now argue that because the members of his constituency expressed their will by electing him to the House of Representatives, then it overtakes the law? He should be allowed to remain there because he's the person the people wanted, notwithstanding that he was not legally qualified to be there. So the will of the people is necessarily circumscribed by the facts, circumstances, and the law applicable to the facts of to the individual or the circumstance of his victory. So if the victory is truncated by one thing or the other, the will fall. And we can't keep insisting on this will as if it is an immutable thing, standing on its own and cannot be moved by anything. If there is a legal disability, it takes away the basis of the expression of the will of the people. It crumbles. It can't stand.
Practically speaking now, I'd like us to look at the practicability of some of the judgments. So you have an election, right, that two people contested for or more, and majority voted for a certain person. Imagine 80% of the voting population, which by extension might signify that 80% of the whole population actually went for that candidate. And, you know, the process went on, a winner was declared, and in court it was overturned, and the victory was given to the person who got 20% of the votes, meaning that, I mean, he's the candidate of 20% of the population by extrapolation, if we could just use that statistical expression. So the practicability is the fact that he is someone who was chosen by 20%. Clearly, the majority of the populace did not want him to be the leader. So in terms of practicability, don't you think the court should still somewhat rely on some form of, you know, the will of the people? I mean, you have jurists, for example, having to decide who was guilty or not. So don't you think the judge or the judiciary should still have something in place that still reflects the will of the people eventually when those judgments are given?
Well, let me...
So Sigwe first, then we can get you to respond.
20%, the 20% okay, is a majority votes in that circumstance. The 80% votes are nullified.
Wasted votes.
Wasted votes. They are not. In every election, what is used to declare a winner is
valid votes.
Valid votes. Votes said to be lawfully cast.
For a valid candidate.
Sorry, I'm still trying to wrap my head. Pardon me. I'm still trying to wrap my head around
could have
calling
80%.
Pardon me. I mean, it's the wasted votes part, because these people went out to select a leader. I mean, So how is it wasted? Because I don't seem to understand. Is that fair?
The issue of fair or otherwise is subject of law. What is fair in law may be unfair to an ordinary man.
Absolutely.
I want you to understand that. The law says you will score a greater percentage of the lawful votes cast. There is no election petition you read that this clause is not expressed there. I scored this percentage of the lawful votes. This man who has scored 80% of the votes is per se not qualified. If you are not qualified, whatever vote is placed on your head will collapse like a pack of cards.
So let me ask you then,
Yes.
let me take it from here and ask you, at what point would you say that we have gotten to the situation of the United States where when electoral cases are referred to the courts will decline and say no, go back to the ballot box, go back to where the will of the people was expressed? At what point will we get there in Nigeria?
Well, it depends on what was referred to the courts. The court cannot create an imaginary situation. It depends on what is put. Equally, in Nigeria today, you can come to court, and the court, looking at all what is presented before it, especially in a governorship or presidential election, where the issue of spread is one of the qualifying factors to become a governor or a president. If Mr. B has been disqualified, but even at that, the votes that are on ground are not enough to meet the constitutional requirements, no, you would not be declared a governor. You will go back. The court will say, please, a re-election has to be conducted. This time, not with the man who scored the highest number of votes, but with the man who came next to you. So that's what it is. The law has put, the Electoral Act has defined all of this completely. It's just that, like what I said from the beginning.
Well, let me quickly allow...
the very day we separate ought from is.
Yes.
Look at it right.
Let me quickly allow Mazi, give his last words on this, because time is fast spent. I don't know, do you want to quickly comment on, because those were your first comments, that we're not yet there. At what point will you say that we will get there, or we are finally there, where the electoral culture has taken over in such a way that we don't see the courts as a place to go to?
Yeah, it starts from ensuring that there's internal democracy in parties, that the process of emerging as candidates of political parties is such that will not give rise to litigation, that the political climate or system and culture is such that respects the rule of law and ensures that the requisite environment is put in place for the conduct of an election, and that the election itself is not in any way carried out in a manner as to rob it of the integrity or trust of the people, so that when an election is now conducted, the people will have confidence and they believe that the outcome of this electoral process reflects the will of the people, and then the candidates who lose will accept the outcome as being the legitimate outcome of the process. When we get to that point, the courts will now have little or no role to play in the matter.
Well, I guess that's where we're hoping we will head to. We hope that that's where we'll be headed. Well, I believe that this conversation will be ongoing. Something that could also take the time of maybe those looking at the election, the Constitution Amendment, and maybe even in the National Assembly. But we have to thank you both for coming on Sunrise Daily this morning. Mazi Afamosigwe is the Senior Advocate of Nigeria and former General Secretary of the Nigeria Bar Association. And we also had Chief Utum Eteng, who is a former member, Presidential Committee on Constitution and Electoral Review, and also a member of the All Progressives Congress. Well, that's it for this segment. We'll come back now and we'll be talking about state of the nation. Please stay with us.